you know it's what I always wanted. Could never have too many things. Well, you quit kicking me under the table. I'm trying, will somebody make us shut up about it? Can we settle down,
Shalom, this is your Ark. Yah is magnified, coming back with another informative video. I titled this video Non-Negotiable. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All of my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, let's get to it. Oh yeah, but before I move any further, I'd like to thank everyone that's been emailing me, calling me, asking me am I okay and everything. Yeah, I'm all good. Everything is good on my end. I just been so busy, I haven't been having time to make videos. Okay, but since I finally have free time today, I will be making a video today, and I will be posting this video today. Okay, but this video is going to be for the state of South Carolina. But it's good in any state. You can use it in any state. But because I have an Ark that gave me a gift for assistance to help him with his situation, and he's in South Carolina, I'm going to surprise him today with a video for his situation, for he can get better understanding of what's going on and how he can handle himself in court, with the proper ways of understanding. Okay, what I will give to him today, and anyone else who's in South Carolina who needs assistance, or whoever just needs assistance with fighting this situation, period, dealing with this child support stuff. Okay, so now as you all can see, we're coming from the state of South Carolina, Department of Social Services, Child Support Enforcement Division, Administrative Process, right? Then it states Notice of Financial Responsibility. Okay, so he received this, in the mail, but as you can see, it has 2, I crossed that out, case number crossed out, employer I crossed out, which is all his information, right? And then it states the Child Support Enforcement Division, pursuant to South Carolina Code Section 6317, 710. But that's a mistake. It should be 6317, 750. Right? Then it says notifies you that you have a duty to support and provide the medical needs of the following child or children. Right? As you can see, I crossed out his offspring's years of birth. But let's continue. In the custody of blank, which would be the child's mom. Okay, even though child support doesn't deal with custody, so they don't know if the child's in the custody of her or not, because they don't have the rights to deal with custody. Custody issues and child support are totally different. So if there's no court order stating that the child mom has custody over the child, then child support do not have the right to appoint custody, the custodial parent to anyone. Okay, they cannot name the mom custodial parent, or they cannot name the dad custodial parent without a custody court order from the custody courts. Okay, child support and custody are 2 separate situations with 2 separate jurisdictions. Child support do not have jurisdiction to appoint a custodial or non-custodial parent. Okay, but let's continue. Number 2, it says you are required to appear on blank at 9 a.m. for a negotiation conference to determine the amount of your duty of support. The negotiation conference will be held at Lee County Family Court, Lee County Courthouse Square, 2nd floor, Bishopville, South Carolina. So now, as you all can see, they want him to come and do what? Negotiate. At where? The negotiation conference. Okay? You have a right to negotiate or not to negotiate. But once you negotiate, then you consent. And we're going to go over that as well. Okay? But let's continue. It says, you may assert the following objections in the negotiation conference. A. The dependent children was or were adopted by a person other than you. B. The dependent child or children is or are emancipated. Or C. There is an existing court or administrative order for the child support. Then it says 4. If such if such objections are not resolved at the negotiation conference, the division will schedule a court hearing. A notice of hearing indicating the date, time, and place will be provided to you. Okay, so basically stating that, okay, if you don't negotiate at the negotiation hearing, then they will send you in front of a judge to negotiate. Either way, it's still a negotiation hearing. Okay, and it takes your consent to negotiate. Okay, I tell y'all, we don't negotiate, we don't argue, we do none of that. Okay, it's nothing to negotiate about. What you look like negotiating about your own property and your own offspring. That's yours. You don't have to negotiate with no one about what's yours already. It's already yours. How do you negotiate with something that's already yours? Okay, but let's continue. So before I move further, let's go to the definition of negotiation. So let's go there. Okay, so now as you all can see, we're coming from the Black Laws Dictionary. We're going to pick this up at the term negotiation so we can get better understanding. Negotiation means the deliberation, discussion, or conference upon the terms of a proposed agreement. So now we know what a proposed agreement is, or what an agreement is. An agreement is consent to what? A contract. That's agreement. Okay, but let's continue. The act of settling or arranging the terms and conditions of a bargain, sale, or other business transaction. Okay, so when you go into these courts, like I told you all, you're going to these courts as corporations or as corporate fictions. Okay, which is the all caps name, the ends league is the straw man, the trust, the legal person, whatever you want to call it. That's what you're going to these courts as. Okay, and same thing with the other side, which is your child's mom. She's going in as the exact same. Against what? Or with what? The exact same entity creation of the state, which is also known as the child support agency, which is another legal fiction creation. Okay, it only exists on paper, and everything that goes on in the courts only exists on paper. That's why a court's order, that's why a court only speaks through its orders or through its written orders, meaning that it only speaks through what's on paper. Okay, that's it. That's all. Same thing with you all. It only exists that's on what's written on paper. Okay, you need your documents to beat you into these courts. Okay, you need these documents. You need to be running a fight, stand up for yourself, and understand what's really going on, and stop consenting to these things. But let's continue. It states the act by which a bill of exchange or promissory note is to put into circulation by being passed by one of the original parties to another person. So now, basically, when you go into these courts, they are creating the promissory note. And when they create that promissory note, they want to pass the obligation on to this person that's also known as the non-custodial parent. Now, if you want to be the non-custodial parent, you will voluntarily go in there as the corporate fiction and agree to negotiate. And once you decide to agree to negotiate, boom, they got you. Now you must follow all the terms and conditions of the contract. Now, if you never wrote up the contract, and you had no part of writing up the contract, but you want to go in and negotiate a contract, then you already plan on uneven ground. Because the contract will only benefit he who wrote it. If you didn't write the contract, then you know it's not going to benefit you. So why go in there and negotiate? Okay? But in order for them to have a negotiation, again, you must negotiate. So let's go to the definition for the word negotiate. Negotiate. To transact business. Again, taking you back down like negotiation. It's all a business transaction. They can care less about your living, breathing offspring. It's not about them. It's about commerce. That's it. That's all. But let's continue. To treat with another, respecting a purchase and sale, to hold intercourse, to bargain or trade, to conduct communications or conferences. It is that which passes between parties or their agents in the course of or incident to making of a contract, and is also conversations and arranging terms of the contract. Okay, so again, to negotiate is to what? Is to create the contract, which will also create what? The bill of exchange. And when you get that, boom, they gonna pursue after you. Okay, but let's continue. Let's go to negotiable, because in order for them to be a negotiation, they must be a what? A negotiable instrument. So let's go to the definition of the term negotiable. Okay, so now as you all can see, we're still coming from the Black Law Dictionary. We have the definition for the term negotiable. Negotiable, capable of being transferred by endorsement or delivered so as to pass to the holder the right to sue in his own name and to take free of equities against a signer or payee. So remember, I tell you, they can only sue in name or be sued in name. But let's continue. An instrument embodying an obligation for the payment of monies is called negotiables. So now, if they send you a billing statement in the mail, then that bill is known as a what? It's a negotiable instrument. Okay, meaning that that once they see you, that you can negotiate the terms. It's a negotiable instrument. But let's continue. When the legal title to the instrument itself and to the whole amount of money expressed upon its face, when the right to sue therefore in his own name may be transferred from one person to another without a formal assignment, but by mere endorsement and delivery by the holder or by delivery only. So again, as you all can see, once they create the instrument that forms the obligation, that instrument is now a negotiable instrument. Okay, and any negotiable instrument you can negotiate on. Okay, if you do it the right way. Why? Because it's called a negotiable instrument, made to negotiate with. Okay, so now with that being said, let's go back to the state of South Carolina state codes so we can see what this negotiation hearing is all about. So with that being said, let's go there. Okay, so now we're back for all my people in South Carolina. But like I stated before, just if it's code in South Carolina, it's in every state. Okay, they all have the same rules and they all got to follow the same federal guidelines. Okay, but let's pick this up. It says 2012 South Carolina Code of Laws, Title 63, South Carolina Children Code, Chapter 17, Paternity and Child Support, Section 63, 17, 750, Negotiation Conference, Consent Order, and monthly obligation. But a key word in this is a consent order. So they need your consent to do what? To make an obligation for what? Monthly support. Okay, but let's continue. Let's pick this up at A. A. An obligor who has been served with a notice of financial responsibility pursuant to 63, 17, 740 and who does not request a hearing pursuant to 63, 17, 780 shall appear at the time and location stated in the notice for a negotiation conference or shall reschedule a negotiation conference before the date and time stated in the notice. The negotiation conference must be scheduled not more than 90 days after the date of the issuance of the notice of financial responsibility. A negotiation conference may not be rescheduled more than once without good cause as defined in regulations promulgated pursuant to the Administrative Procedures Act. If a stipulation is agreed upon at the negotiation conference as to the obligor's duty of support, the division shall issue a consent order setting forth. So once you agree, which means once you make an agreement to their contract, which we just read, because to negotiate means to enforce or to create a contract, you then consent to that contract, which is also known as an order. But let's continue. Number 1, the amount of monthly support obligations and instructions on the manner in which it must be paid. Number 2, the amount of arrearage due and owing and instructions on the manner in which it must be paid. Number 3, the name of the custodian of the child and the name of the birth date of the child for whom support is being sought. Number 4, other information as set forth in regulations promulgated pursuant to section 63, 17, 730. B, a copy of the consent order. There it is again, of the consent order, meaning a copy of your agreement that you agreed to, okay, issued pursuant to subsection A. The proof of service must be filed with the clerk of the court of the county in which the obligor resides, or if the obligor does not reside in the state, with the clerk of the court of the county in which the obligee resides. The clerk shall stamp the date of receipt of the copy of the order and shall assign the order a case number. The consent order shall have had all the force, effect, and remedy of an order of the court, including but not limited to, pay close attention y'all, income withholding and contempt of court. Execution may be issued on the order in the same manner and with the same effect as if it were an order of the court. No court order for judgment nor verified entry of judgment is required in order for the clerk of the court and division to satisfy past due amounts of child support past due child support to the Internal Revenue Services or the State Department of Revenue for purposes of intercepting federal and state refunds or credit bureau reporting. So once you consent, then you gave your rights up for them to do everything that they want to do. Okay? Basically stating that you agreed to the contract. But like I stated, if they send you something trying to collect money, then that's a what? A negotiable instrument. But let's continue. C. If no stipulation is agreed upon at the negotiation conference, the division shall file the notice of financial responsibility and proof of service with the clerk of the court of the county in which the obligor resides, or if the obligor does not reside in the state, with the clerk of the court of the county in which the obligee resides, and the matter must be set for a hearing in accordance with section 63 1780. So once you don't agree to go to the negotiation, then they want to set up a hearing for you to go before a judge and negotiate. It's still a negotiation hearing. Either going to be before the agency for the court, before the agency, or they're going to send you before an acting judge in a courtroom that's going to try to intimidate you by threat, duress, and coercion to try to force you into a contract. Okay, and to force you to consent to an order. But let's continue. The determination of the monthly support must be based on child support guidelines as set forth in section 63, 17, 47, 470, and 43, 5, 580. Okay, so for all my brothers in South Carolina, okay, this is what you're dealing with. So you got to fight. You got to stand strong, okay? But not only that, let's go now to your remedy, okay? Let's go to your remedy. So with that being said, let's go to the title of the video. It's called Non-Negotiable. Let's go to what non-negotiable means. This is your remedy. Let's go there. Okay, so as you all can see, we're picking this up from the Black Law Dictionary again, where it says non-negotiable. It states, not negotiable, not capable of passing title or property by endorsement and delivery. So when we just read the definition of negotiable, it stated that once the bill of exchange is created, then they're going to pass it on to what? Another person, which is also known as what? The obligor, to take care of what? The obligation that was created. Okay? So when someone tells you all to go to court or learn how to negotiate, nah, it's no negotiating. Okay? What are you going to negotiate for your own property for? Why are you going to negotiate, your own offspring that came from you? There's no negotiating. It's a non-negotiable instrument. I'm not here to negotiate. They're in these courts talking about the fiction. I'm not talking about the fiction. I'm talking about a living, breathing offspring, that came from my bowels. Okay? That's what I'm talking about. They talking about the state created entity. I'm not here to negotiate on behalf of that. And I don't give no one in this court the right to negotiate on my behalf or the behalf of my living, breathing offspring. That's it. That's all. This is a non-negotiable fact. Okay? So, when you all go to these courts, just be prepared, be ready. You all can do it. Just know what you know. Study hard. Go back and watch my videos. Okay? We don't need no third-party interveners trying to come on your behalf to negotiate on your own for your own property. Nah, that's yours. It came from your bowels. So all my brothers out there fight, continue to fight. All the ladies out there fighting. Don't want to leave y'all out. Y'all continue to fight too. Okay? Let's get this thing moving. Let's get this ball rolling. If you all need my help, hit me up in my email at y'allismagnified@gmail.com. If you serious, be serious about it. Let's do something. Try to do something about this. We don't have to sit back and take what's going on, okay? So, again, that's all I'm going to do for today. You all be blessed. Like, share, and subscribe. Shalom.